Welcome to this presentation on the U.S. Supreme Court decision Dobbs versus Jackson and what it means for people of faith. My name is Mark Mann. I'm the Director of Program and Institutes here at the Catholic Information Center. The ministry of the center offers opportunities for folks who are already Catholic to have opportunities for deeper, more reflective awareness of our faith. We also invite those of different faith traditions or no faith tradition at all to dialogue with us about this way of life. We're a ministry of the Paulist Fathers and at service to the Diocese of Grand Rapids. And I just want to take an opportunity to remind everyone that the programs here at the Catholic Information Center are open to the public. We are donation-based. And so this evening would not be possible without your contributions and those of our friends and associates. Thank you. Your support is indispensable. You can also connect with us by signing up for our free newsletter that we send out on Thursday afternoons, talking about upcoming programs, as well as includes helpful articles about events that are happening today. And you can also watch videos, including the recording of this evening's presentation on our YouTube channel. And of course, you can follow us on social media. Your support is a big help of everything we do. And you're always welcome to visit us here at the Catholic Information Center. As we continue, I want to take a moment to acknowledge the tragic loss of life in Valdez, Texas, as well as in Buffalo, New York. Bishop Okoviak, the bishop here in the Diocese of Grand Rapids, shared that we find ourselves once again in overwhelming shock and grief as a nation over the senseless loss of innocent life. This time, the pain is deepened by the fact that almost all of the victims are young children.
Yes.
Okay, thank you.
Sorry, hi.
Archbishop Gustavo Garcia Siller, who is the Archbishop of San Antonio and the Archbishop for the people of Uvalde, shared that the Catholic Church consistently calls for the protection of all life, and these mass shootings are the most pressing life issue, are a most pressing life issue on which all in society must act, those elected officials as well as residents. So let us take a moment of silence. Please join me in praying for the children and adults who have died and for the families and friends who are grieving the death of their loved ones. And let us pray as well for Salvador Ramos, the young man involved in this incident, and for his family who are also grieving. And we pray too for the wider communities in Uvalde and as well as Buffalo and all those who have been impacted by these tragedies. As Catholics, we mark the ascension of the Lord this Sunday. Let us hold fast to our faith in the risen Lord, the Prince of Peace, who has conquered evil and death. Let us pray. God, our loving Father, you formed us in our mother's wombs. Through the Holy Spirit, you pour forth your love into our hearts. And in the death and resurrection of your Son, Jesus, you call us home to heaven. Grant wisdom and insight to those who govern us, compassion and courage to those who work to defend human life, and safety and care to every human being, especially the least among us. We ask this in the name of our Lord Jesus, your Son, who lives and reigns with you in the Holy Spirit, one God, forever and ever. Amen. In the name of the Father, the Son, and the Holy Spirit. Amen. Pleased to welcome Mr. John Bursch, who has argued 12 U.S. Supreme Court cases and more than 30 Michigan Supreme Court cases over the past decade. He served as Solicitor General for Michigan from 2011 to 2013. John defends religious liberty, free speech, and the right to life, while also representing Fortune 500 companies, foreign and domestic governments, and top public officials, primarily all on appeal. He was inducted into the American Academy of Appellate lawyers and serves as a member of the American Law Institute. Please help me welcome Mr. John Bursch.
Thank you, Mark. Well, I'm very pleased to be here because this topic of what a post-Dobbs world is going to look like is so important, but especially in Michigan, because if you're following the news, Michigan has kind of become the leader in what a post-Dobbs world looks like with respect to actions in the court system, actions of executive officials and others, all trying to maintain the ability to take innocent unborn life. And so to have a deeper understanding about what the US Supreme Court is doing and what's happening in Michigan, both with respect to the court cases that the governor and Planned Parenthood have filed, but also this awful ballot initiative that is now circulating, this is just an ideal time to be talking about these topics. So I'm going to try to make our time tonight as productive as possible and still leave time for questions at the end. So I'm going to start with just a little bit of Roe versus Wade history to make sure that we're all starting from the same place. Then going to discuss the Dobbs case itself, how it got there, what it means, what this leak from the US Supreme Court means, and when we can expect to see a decision, what the ramifications might be. That'll all kind of be part one. Part two will then focus on the actions in Michigan's court system right now. Planned Parenthood and Governor Whitmer have filed suit seeking to establish a right under the Michigan Constitution to take unborn life. And I represent Right to Life of Michigan, as well as the Michigan Catholic Conference in that litigation. And we're very pleased to be standing up for life. Then I'll address the ballot initiative, which is extremely disturbing. You've probably heard about the ballot initiative, but we're going to walk through it kind of line by line so that everyone can understand fully exactly what it would do if it became part of our Constitution. And then finally, we're going to discuss what all of us should be doing during these troubling times. You know, everything from prayer to action steps that you can be taking. After those four parts, then I'll open it up for questions from anyone, and I'm happy to take those on any topic. So first, part one, let's start with Roe and Dobbs. All of you, I'm sure, are very familiar with Roe versus Wade. It was decided in January 1973, and it created out of whole cloth a constitutional right to abortion in the US Constitution. Now, when I say created out of whole cloth, what do I mean by that? Well, the US Constitution is absolutely silent about the topic of abortion. And so when the Constitution is silent, then matters trickle back down to the states for regulation. The federal government and the federal court system doesn't have anything to say about that. But as you know, there's certain privacy protections in the US Constitution, and the justices in Roe said that based on the penumbra of those privacy provisions, just kind of buried in them, we're not sure exactly where, there's this hidden right to abortion that no one knew from the time that the 14th Amendment was adopted until 1973. It is truly a constitutional doctrine that has no rooting, no basis, no foundation in the Constitution at all. Now, while many people know about Roe, very few people know about Doe. And Doe was the companion case to Roe. They were argued at the same time. They were decided on the same day. And Doe added an important gloss on Roe versus Wade. The holding in Doe was that this right to abortion, which was basically set up through the time of viability. After that, states could do some amount of regulation to protect life, to protect women, to protect against the coarsening of society. But Doe says that when it comes to a woman's ability to take the life of her child, that if she invokes physical health or mental health reasons, that those would extend her rights basically all the way to the end of pregnancy. So in reality, with only certain small ways that states can impose any kind of a safety and pro-life regime on these types of situations, that the US Constitution protects abortion from conception to birth. And this is going to be important when we talk about the ballot initiative, because that's what Planned Parenthood is trying to enshrine in our state constitution with words that will be actually in the Constitution as opposed to made up in a judicial opinion in Roe and Doe. So we've been fighting against this Roe regime for about 49 and a half years now. Because the Supreme Court decided it as a matter of federal constitutional law, it basically took the ability of all of us working through the democratic process to have any conversation and meaningful debate about whether it's appropriate to take human life at any stage of development. And it might not surprise you, maybe it will, that the United States is one of only 4 countries in the world, including North Korea and China, that would allow the taking of an unborn infant's life all the way up until the baby is literally coming through the birth canal. And so for years, pro-life advocates have been enacting legislation and then pursuing that legislation in the courts when it gets challenged to try to put some dents in or eventually overrule Roe. So our first opportunity to do that was in the Casey case. And that was the last time that we had a majority of what we thought were justices committed to applying the plain text and original meaning of the Constitution. But at the last minute, some of them got cold feet and they ended up reaffirming Roe, saying that because it was a precedent, the court should respect that even if it was wrongly decided. Now, as a matter of constitutional law, that doesn't make sense. Justices take their oath of fidelity to the Constitution itself, not to any opinion that puts a gloss on that Constitution, so that when a case is grievously wrong, as Roe is, their responsibility is to step in and correct it. But that didn't happen, and so the Roe regime continued. Well, then Mississippi comes along, and they passed a model law that protects innocent human life beginning at 15 weeks gestation and later. Now, the reason why 15 weeks was important is that that viability line that I mentioned is the one that beforehand, states are not supposed to be able to prohibit abortion altogether. And the viability line is generally recognized by most medical professionals to be at 21 to 22 weeks. And so a 15 weeks law came into direct confrontation with the viability holding in Roe and Casey. And that law was immediately challenged and Mississippi defended it. Because of the Roe precedent, they lost quickly in the court and again in the Fifth Circuit Court of Appeals. And then they filed their cert petition. And at that time, the Supreme Court looked different than it did today. Justice Kennedy had not yet retired. Justice Ginsburg was still on the court. She had not passed away yet. And so the hope was that perhaps the Supreme Court would at least overturn the viability line holding in Roe. But there wasn't a whole lot of hope that it would go much farther than that because Justice Ginsburg was a very ardent supporter of abortion rights. She had 3 other colleagues who were as well. And Justice Kennedy, in many abortion cases, sided with upholding Roe. So the hope was maybe we could draw him across the line and eliminate the viability line. So the cert petition gets filed and it sat there for a long time. In the meantime, Justice Kennedy retires and Justice Gorsuch is appointed to replace him. And then the petition gets granted and some things happen very quickly. Justice Ginsburg passed away. I'm sorry, Justice Gorsuch replaced Justice Scalia. So Justice Kavanaugh replaces Justice Kennedy. And then Justice Ginsburg passes away unexpectedly. And then Justice Amy Barrett takes the bench. And so now all of a sudden, instead of this very close court, we have 6 justices, including the Chief Justice, who are committed to an originalist understanding of the Constitution. And so Mississippi very smartly changed course once it got to briefing and arguing the merits of the Dobbs case. Instead of just asking for a holding that would eliminate that viability line and allow states to protect life, protect mothers, and protect the human culture at earlier stages of the pregnancy, they said, well, there's no need for you to decide where the viability line should be because that's not rooted in the Constitution. In fact, Roe versus Wade itself is not rooted in the Constitution. And so it's time to take this out of the federal jurisprudence and give the issue back to states and local governments, which then can have those political dialogues and enact their own laws deciding how to protect life at the state and local levels. Well, this got the attention of the country very quickly. The US Supreme Court tends to be a lightning rod for controversy because so little happens in our Congress anymore that most of the important national policy issues are being decided through the court system. But really nothing is bigger politically than abortion. It's become almost a sacred religion of its own for some. And so the court heard oral arguments last fall, and they went very well for those who want to be able to protect life. The eyes were really on Justice Kavanaugh and Justice Barrett as the newest justices to try to get a pulse for where they might be. And Justice Kavanaugh said something very encouraging during the oral argument. He asked the abortion clinic's lawyer, well, when the Constitution is silent about an important and controversial political issue, isn't it the role of the US Supreme Court to remain scrupulously neutral about that topic? In other words, let's get us out of the business of abortion in the Constitution and let it go back to the states. And the other justices echoed very similar comments. There were many questions and statements from the justices about the lack of foundation that Roe had in the Constitution, and to the extent that there were justices who were pushing against overruling Roe, their arguments were really difficult to understand. Justice Sotomayor, for example, said that the question of when human life begins is really a religious question. Well, it's not a religious question, it's a scientific question. If you ask almost any doctor or scientist, they will tell you that life begins at conception and that every baby is human. There's no scientific debate about that. Justice Breyer made the comment that the people of the United States had delegated the authority to decide the question about abortion in the Constitution to the US Supreme Court justices in 1973, which of course is a completely inaccurate statement. No one delegated that power to the justices, they just took it to themselves. So both from the perspective of the comments that the pro-life originalist justices made, as well as those on the other side, everything seemed to be looking pretty good. And so now we were just going to hunker down and wait for an opinion to come. And then something unprecedented happened just a few short weeks ago. A draft opinion at the US Supreme Court was leaked. Now, there have been minor leaks at the US Supreme Court in the past, leaks about potential outcomes in certain cases, leaks about how certain justices discussed at conference or talked about a case before it was decided, but never has there been a leak of an entire opinion like this, and certainly not in a case of this import. And so that left many of us kind of scratching our heads, wondering who would do that, because it almost certainly wasn't a justice. If they had done that, their ability to trust each other would diminish significantly. And even when they disagree, it's a pretty collegial court because after all, they're appointed for life. And so they need to get together and coexist for a long, long time. It's like one big family. But for a court staff member or for a clerk to have done that would likely be the end of their career. And so all we can do is speculate who might have done it and then wonder if it was done to exert political pressure. And certainly there has been political pressure exerted on the court since that opinion came out. Just as a refresher, the draft opinion, which was actually quite old in terms of the Supreme Court decision-making process, it was dated all the way back in February, purported to be a draft of a majority opinion on behalf of 5 justices by Justice Alito. And it pretty much marches right down all the arguments that Mississippi had advanced as to why Roe should be overturned and that the question of abortion should go back to states. One of the politically helpful things about the opinion from the court's perspective is that it would get the US Supreme Court out of the abortion debate, and that debate would then take on a greater effect in state legislatures and in ballot initiatives and things like that. But the pressure started immediately. There were calls to impeach justices, to pack the court. We've heard that for a little while. There were protests on the courthouse steps. Very disturbingly, there were protests at the justices' homes. Some of their addresses were publicly published on the internet so that those protests could take place. And there were even protests that took place in front of and inside Catholic churches and at pregnancy help centers and other places that supported the pro-life cause. But no one has backed down yet. Now, one of the interesting things about that draft opinion is that there were only 5 justices who were willing to join it. Chief Justice Roberts, who at least theoretically should be with us on this issue, expressed an interest at oral argument in issuing a narrow opinion, perhaps one that eliminated the viability restriction in Roe, that upheld Mississippi's 15 weeks law, but didn't go so far as overturning Roe versus Wade. And at least at that draft stage, it doesn't look like that he made it. And so now, our job is to continue praying for those justices. So your very first action item is to pray for the justices on the Supreme Court, to pray that they have courage in the midst of the protests and the threats and the political wrangling and all those things, and that they stand not only by pro-life principles, but by just basic constitutional principles, and that they reverse this really terrible and unfounded decision. I also would like you to pray that the justices continue to remain in good health. Justice Thomas was in the hospital for a couple of days only a few weeks ago, and if something were to happen unexpectedly to any of the justices, then they're not allowed to cast a vote in the case, even if they've already cast a preliminary vote in favor of a particular decision. If we lose one of the justices in that 5-justice majority, then if Chief Justice Roberts follows his course, it would be a 4-1-3 decision. And you need 5 votes for a majority opinion. So Chief Justice Roberts' opinion, if that's where he stayed, would be controlling and Roe would not be reversed. We would be left in a much better place because states could protect life at earlier stages of pregnancy before viability, but it would not get us where we want to go. So please pray for them. Do not write a letter to the justices or to the court Don't go out and counter protest in any of their homes if you're thinking about that. But certainly pray for them, and to the extent that you have friends, family member, neighbors who are curious about what this is all about, help explain to them that this decision is really not that monumental. I mean, it is in the sense that Roe is being reversed, but all the court is doing is correcting a mistake and allowing these decisions to go back to the states and to the local governments. So that there's a political process that everyone will be able to participate going forward. So that's the action items with respect to that. So assuming that the US Supreme Court does go ahead and it issues this opinion that we saw in draft form, that immediately will throw the country into this post-Dobbs, post-Roe world. And Michigan is the tip of the spear when it comes to what a post-Dobbs world is going to look like, although this will quickly be replicated in many, many other states. The states are in a bunch of different positions when it comes to their laws in the event that Roe is overruled. In some states like California and New York, they've passed laws that protect abortion all the way to the end of pregnancy and allow non-doctors to perform abortions and all kinds of other things like that. There are some states that have modest regulations, other states that have what are called trigger laws that will go into effect if Roe is overruled. But Michigan is one of a small number of states which still has its original pre-Roe statute in place. Now, some of you may know that Michigan was the first English-speaking country or English-speaking government in the world to prohibit the death penalty because of our citizens' commitment to life. And so given that, it should be no surprise that all the way back in the mid-1800s, Michigan passed a law that made it a crime to perform an abortion in our state, to take the life of an innocent unborn child. And that law was reenacted in slightly different verbiage in 1931, so that's about 90 years ago now, that does the same thing. And that law is still on the books because it was never repealed. There are court judgments that say that statute can only be enforced up to the limits of Roe versus Wade, which is why we continue to see abortion clinics performing abortions in our state. But if the restriction of Roe is eliminated, then that statute springs back into full force. And so we will immediately become a pro-life state. And for those pro-choice groups and officials in our state, that has caused a very, very strong response. So starting with the litigation, and then later we'll get to the ballot initiative. The litigation started on the same day in April with 2 different lawsuits taking place in 3 different locations. First, Governor Whitmer filed a lawsuit in Oakland County Circuit Court, which is a Michigan trial court, and she sued all of the county prosecutors in the counties where abortion clinics are located. So the only ones who could enforce that 1931 pro-life law that protects innocent life. And her argument was that the Supreme Court could, maybe even was likely to overrule Roe versus Wade. And as a result, the Michigan courts should recognize a right to abortion in Michigan's constitution. Now, again, right off the bat, this claim doesn't make any sense in the same way that Roe doesn't make any sense. You can look all the way through Michigan's constitution. It was ratified in 1963, and you will not find a single reference to abortion in it. What's more, that 1931 pro-life law had already been on the books for 32 years at the time the Constitution came into effect. And yet we have no historical record of even a single person in 1963 suggesting or advocating that somehow the Constitution created a right to abortion that would conflict with that pro-life statute and make it invalid. There's just none. There's nothing out there. And then much later, there was a challenge where someone asked the court to hold that there was a right to abortion in the Michigan Constitution. And in a published decision, the Michigan Court of Appeals, not the Supreme Court, but the Michigan Court of Appeals, said that there was not. No right to Michigan abortions in our Constitution. It's silent about that. And yet that's what this complaint asks the courts to find. So that case is pending in a Michigan trial court, Oakland County. At the same time, Governor Whitmer went to the Michigan Supreme Court, recognizing that this Court of Appeals decision was going to be a problem in the trial court and the Court of Appeals itself. After all, a published decision is binding on them. She asked the Michigan Supreme Court justices to direct the trial court to certify the case for immediate Michigan Supreme Court review. And the Michigan Supreme Court has 7 justices. And although we don't know for sure because they don't almost ever hear abortion cases, it's widely assumed that there is a 4-3 pro-choice majority on the court. So notwithstanding the problems and the infirmities in this legal theory, for other reasons, they may decide to create such a right. So that's the second place where litigation is pending. On the same day as those requests, Planned Parenthood filed its own lawsuit asserting the same claim, a right to abortion in the Michigan Constitution, in the Michigan Court of Claims. Now, the Court of Claims is a different trial court, one where you bring actions against the state of Michigan or its officers or its entities. And what Planned Parenthood did is it filed suit against Michigan's Attorney General, Dana Nessel, who has the power to enforce the 1931 pro-life law, and asked for an injunction against it. Now, there are all kinds of problems with that theory too, because Attorney General Dana Nessel had already announced that she would never defend or enforce Michigan's pro-life law. And she told the court that too. In fact, she filed a brief with them that said, because I'm not willing to defend, there are no adverse parties here, and so you should dismiss this case for lack of jurisdiction and send Planned Parenthood over to the governor's lawsuit, and they can participate there. That's an appropriate lawsuit. So as for our side, the pro-life side, Michigan Right to Life of Michigan and the Michigan Catholic Conference, we kind of put our fingers in all 3 of these buckets. First, with respect to the Court of Claims litigation, we did not try to intervene because that would possibly create the adversity that would allow the court to go forward. Instead, we filed a friend of the court brief, even before the Attorney General had made any statement in her own brief, explaining that there were numerous jurisdictional bars that the court could not do anything with that case. Number 1, there was the lack of adverse parties. Court can't go forward when you do that. Number 2, there was no threat to Planned Parenthood by the defendant, Dana Nessel. In the absence of that, the court lacks jurisdiction. Number 3, there's a binding Michigan Court of Appeals case out there that binds the court. You can't go forward. And finally, the Dobbs case hasn't even been decided yet. So to the extent any of this is relevant, it hasn't ripened into a dispute. So all kinds of reasons that the case should be dismissed. And yet the judge entered a preliminary injunction that stops anyone from enforcing the law. And it applies not only to the Attorney General, but it purports to apply to the county prosecutors who weren't even parties to the case. And so you might ask yourself, well, how on earth could something like that happen? How could a judge act without jurisdiction? Well, it turns out that the judge in the Court of Claims who got this case assignment used to work for the ACLU, and she represented Planned Parenthood in trying to establish a right to abortion in Michigan's Constitution. As a lawyer, she was the one who litigated and lost the Court of Appeals case that should have now bound her and told her that she couldn't do anything with respect to the law. Only the Michigan Supreme Court could do something like that. This judge continues to be an annual donor to Planned Parenthood. She's even gotten an award from them. And through that funding, indirectly, she is in a way subsidizing the very litigation that's in front of her. So she should have recused herself from the case. Anybody in that situation should have recused themselves because the rest of the world will look at that and not think that pro-life forces are getting a fair shake. And yet she went ahead and entered this preliminary injunction. So we have now filed, and you may have seen this in the news over the weekend, a complaint for superintending control in the Court of Appeals. That's kind of a complicated phrase, which means we're asking the Court of Appeals to take jurisdiction over that judge and dismiss the case. And we'll probably hear from them in about a month or so. So that's the status of that case. Right to Life of Michigan and Michigan Catholic Conference have also sought intervention status in the other 2 actions that the governor brought. And intervention status would allow us to fully participate in that litigation, to file briefs, to make defenses of the Michigan pro-life law, and ultimately, if it's in the trial court, to appeal up the chain, and possibly, depending on what the Michigan Supreme Court does, even ask the US Supreme Court for review, although that could be difficult because this will be a case interpreting the state constitution. So, first of all, what are the takeaways for us with respect to all of this litigation? First, that the pro-life community has banded together and is fighting very, very hard to keep our pro-life law in place. Second, as you talk about this with friends, neighbors, coworkers, people that you meet on the street, because Michigan court litigation always comes up when you're talking to someone on the street. No matter how you feel about abortion, you should be very concerned about this case. Because if the governor, who has taken an oath to enforce Michigan law, refuses to do that, instead sues to try to invalidate it, and the Michigan Attorney General, who has taken an oath to defend and uphold Michigan law and refuses to do that and allows injunctions to be entered against that, then democracy starts to die in our state. Democracy only works when the court system respects the judgment of the people, acting through ballot initiatives and acting through the legislature in bills that are signed by the governor. If you have an executive branch member exercising unilateral power to essentially veto the law, then democracy cannot stand. And so what I've been telling folks is that you may be violently pro-choice. You may agree with the outcome of that injunction and what the governor is attempting to do. But the next time when it's one of the laws that you favor and a governor that is on the other side of that law guts it, sues to invalidate it, the Attorney General fails to defend it and allows an injunction to be entered against it, then you're going to be pretty upset too. And so everyone in Michigan, no matter how they feel about pro-life and abortion issues, should be very disappointed in our public officials, and they need to respond to that at the ballot box. So what can we do about this? Well, first, you need to let other people know what's going on. We're going to have an election coming up this November, and this governor and this attorney general are both going to be running for office. And if you're upset by the positions that they're taking and their failure to enforce and uphold Michigan law, you have the right to share that opinion, and you should absolutely do that. In addition, if you could pray for Michigan, Right to Life of Michigan, the Michigan Catholic Conference, and our entire legal team as we're supporting this, as well as the attorneys for the pro-life county prosecutors who happen to be in the Oakland County and Michigan Supreme Court actions that the governor brought. We could all use your prayers for this. Obviously, when you're dealing with judges who used to represent Planned Parenthood and are writing decisions to get around their own previous losses, which are supposed to be binding on them, it's a very, very difficult situation. So pray that we will be, wise and strategic and even cunning in the things that we're doing, and that if you could pray especially for the judges and the justices on the Michigan Supreme Court, that they will have open hearts and open minds, and that they will apply the law, not their personal policy preferences. We would greatly appreciate that. So now we'll move from the Michigan litigation to this ballot initiative, because it wasn't enough for those who want to be able to continue to take innocent unborn life to file lawsuits. They also wanted to try to paper this with an actual amendment to Michigan's constitution. And so they concocted this reproductive rights bill, which is what they call it, and they're gathering signatures right now. And the pro-choice side has almost unlimited funding. It's unbelievable. They are paying paid signature gatherers $26 an hour in order to try to get the more than 400,000 signatures that they need in order to put this initiative on the ballot. But many of those signature gatherers, and specifically people who are signing those ballot petitions, don't even know what's in this proposal that they're supporting. And so we're going to spend a few minutes now walking through some of this language. And you can find it online if you need it, but I'm going to kind of hit the high points. And if you've got a pen and paper, take some notes, because there's going to be an action item about talking to others about this ballot initiative as well. And this is very, very, very important, because this language will be ensconced in our Constitution for a long time if they're successful. So the beginning of the proposal says that every individual has a fundamental right to reproductive freedom. And we all know what reproductive freedom means. That means the ability to take the life of your child. But they actually go on and they're going to define it even broader than that in ways that may surprise even pro-life advocates on this call. But for the moment, I want to focus on that fundamental right language. We have a free speech clause in our Michigan Constitution, but it doesn't say anything about it being a fundamental right. We have a religious liberty clause in our Michigan Constitution, but it doesn't say anything about being a fundamental right. We have an equal protection clause, we have a due process clause, we have a Headley Amendment, we have all kinds of other things that protect our individual rights, and they're not labeled fundamental rights. By calling this a fundamental right, it elevates a right to take the life of an unborn child above every other right that we have as Michigan citizens. It's breathtaking in its scope. In addition, it says every individual has a right to reproductive freedom. And it doesn't define what an individual is. So that means an individual could be not only an adult, but it could also be a teenager. It could even be a child. So in the past, Michigan has enacted smartly laws that would require parental consent before a minor can obtain an abortion, because that's not the kind of decision that a minor should be making on their own without their parents involved. If you have a 12-year-old at home and they need to have their tonsils removed, there are all kinds of waivers and consents that you will have to give before anyone will be able to take out their tonsils. However, if a 12-year-old became pregnant and they had a school counselor take them to an abortion clinic, or maybe even a boyfriend take them to an abortion clinic, or some other predator, they could get an abortion and there would be no questions asked. They have a fundamental right to do that, and no parental consent or even notification is required. Again, it's kind of breathtaking. So then this goes on and it describes what it means to have reproductive freedom. It says, entails the right to make and effectuate decisions about matters relating to pregnancy, including but not limited to prenatal care, childbirth, postpartum care, contraception, sterilization, abortion care, miscarriage management, and infertility care. Now, that's a lot of things to pack into the meaning of reproductive freedom, or even about abortion. So, for example, take the issue of sterilization. If you have a fundamental right to sterilization, that would include a fundamental right to be sterilized for the purpose of changing your sex if you identified as transgender. What's more, because this applies to any individual, including minors, that would mean that a minor at school, if they had a teacher or a counselor or someone else take them to a gender transition clinic, would have a fundamental right to sterilization without their parents ever even knowing that that was taking place. So they're putting that concept into abortion care and pregnancy and this reproductive freedom right. So how about this suggestion of infertility care? Well, what does that entail? Well, we have laws in Michigan right now that prohibit the payment to have someone serve as a surrogate parent. In other words, to pay someone else to have your child. It's illegal. But if you have a fundamental right to infertility care, that would most likely result in the invalidation of that statute. Similarly, we have very strict laws in Michigan about cloning, prohibiting cloning. In some parts of the world, elementary experiments have been made into human cloning. And if you've got a fundamental right to infertility care, then a good lawyer could argue that you've also got a right to clone yourself if that was the only way that you could have offspring, if you could have your own child. And again, if this language is in our Constitution for the next 25 years, there's no question that that will be invoked. Now then there's this question of abortion care itself. Because that's not defined, it's very broad. And we have all kinds of laws that restrict when you can have an abortion. So for example, a partial birth abortion. It is one of the most gruesome kinds of an abortion procedure that you can possibly imagine. And yet if you have a fundamental right to abortion care, then Michigan's law against partial birth abortions almost certainly won't stand. So this entire first clause is absolutely unbelievable. All right, so then you move to the next phrase, and it says that an individual's right to this reproductive freedom shall not be denied, burdened, infringed upon unless justified by a compelling state interest achieved by the least restrictive means. And so what they're telling some people is this doesn't take away the state's ability to legislate to protect some human life and to protect some mothers and to protect against some coarsening of society. As long as you have a compelling state interest, then you can have some regulation. But the problem is that then the proposal then goes on to define what a state compelling interest is. And it doesn't look anything like the compelling interest that is currently defined by federal law in the wake of Roe and Casey. A state interest is compelling only if, A, it's for protecting the health of an individual seeking care. So that means laws, again, like we have with parental consent, notification, 24-hour waiting laws, providing additional information about the growing child in the womb. All of these things which are collateral to health are already off the table, all of those. In addition, consistent with accepted clinical standards of practice. Well, so there's a healthcare regulation that the state could engage in, but what is an accepted clinical standards of practice? Well, the parties that set clinical standards of practice for abortion clinics are abortion clinics. And so that means any regulation, any health regulation that they don't like, it wouldn't become a standard of practice. So for example, Michigan has a law right now, which most abortion clinics object to, that requires them to have the same level of safety and cleanliness as any surgical center, because after all, it involves surgery many times. Well, if that was not an accepted clinical standard of practice in the eyes of an abortion clinic, then it couldn't be enforced. Likewise, the Louisiana law that went before the US Supreme Court last year involving those who perform abortions being given hospital admitting privileges. So in case there's some kind of an emergency that arises during an abortion procedure, you could quickly get them to a hospital, and that doctor could assist with the medical team at the hospital to make sure that they have the proper care, as opposed to just dropping them off in the emergency room and allowing whatever happens to happen. That would be another standard of practice that abortion clinics will certainly reject, and that's a standard we have in Michigan. So that's the A, that's the B. Then there's another and, C, does not infringe on that individual's autonomous decision-making. Does not infringe on that individual's autonomous decision-making. So that means if the person still wants to do it, then there's no regulation that the state can put in place in order to protect them. It'll always be left up to that individual. So think about what that means. Let's say that you've got an abortion procedure that's taking place in a clinic, and there is a secretary or an accountant or a marketing person there, and the doctor calls them in to assist with the abortion. So long as that patient, the mother who's taking the life of her child, autonomously decides that it's okay for that person to participate, then that would be allowed, and the state wouldn't be able to prohibit that. In fact, autonomous decision-making doesn't mean that any medical professional needs to be involved at all in making a decision like that. All right, so back to the top of the language. It also says that notwithstanding any of the above, the state may regulate the provision of abortion care after fetal viability, yes, that sounds good, provided that in no circumstance shall the state prohibit an abortion that in the professional judgment of an attending healthcare professional is medically indicated to protect the life or physical or mental health of the pregnant individual. So that physical or mental health standard, that's the same one that Doe, the companion case to Roe, put into law. And it's not a very high standard. If you invoke anxiousness or stress about having a child, that would qualify as a mental health condition that someone could say qualifies you for an abortion. Or the fact that I'm going to have back pain if I go into labor, that could be a physical health exception that would allow you to have your abortion. And you might say, well, wait a minute, it said an attending healthcare professional has to indicate this. And doctors would never do that, would they? Well, an abortion doctor certainly would, but you don't even have to go to one of them, because a healthcare professional is a defined term in Michigan law. And it includes dozens of people, including your dentist, your chiropractor, even your massage therapist. So if you tell your massage therapist that you're really stressed out about having a baby, you're thinking about an abortion, your massage therapist would be able to say, oh, well, in my professional judgment, I think that an abortion would be beneficial to your mental health. So even though the state might try to put in place provisions to protect innocent human life after viability, as a practical matter, that following clause takes it away. And so in talking to folks about this, they need to understand that this is nothing less than an authorization to have abortions all the way through the moment the baby comes through the birth canal. If you had a mother who has reached full term of pregnancy, she's 3 days past her due date, the baby is completely healthy, it can survive outside the womb, an abortion could still take place if the massage therapist said that it would be beneficial for the mother's mental health. Continuing, section 2 of this ballot initiative says the state shall not discriminate in the protection or enforcement of this fundamental right. Well, what would that be getting at? Well, Michigan currently treats abortions differently than other things in a variety of ways. And one important way is with respect to taxpayer funding. There's a Michigan statute that doesn't allow Medicaid monies to go towards the performing of an abortion procedure, because there are so many people who are not only offended by the taking of human life, but would never want their dollars going to the government to fund that kind of evil murder. But if the state says no taxpayer funding for abortion and doesn't say that in other areas, an attorney will argue that that's discrimination against the enforcement of this fundamental right. And so that potentially puts bans on taxpayer funding of abortion on the chopping block as well. And yet there's more. It says that the state shall not penalize, prosecute, or otherwise take adverse action against an individual based on their actual, potential, perceived or alleged pregnancy outcomes, including but not limited to miscarriage, stillbirth, or abortion. Well, why would you put something like that in there? As things stand, you don't have to worry about being prosecuted or having adverse action taken against you as a mom, even if you do take the life of your unborn child, because Michigan's pro-life law only applies to the person who is performing the procedure, the doctor or other person who performs the abortion. So this is completely unnecessary. So why would they put that in there? Well, it's because of the perceived or alleged pregnancy outcomes. That means if someone is at home and they deliver their baby and then allow them to die, even after birth, that would be a perceived or alleged pregnancy outcome. And so the state not only wouldn't be able to penalize that person for taking the life of their born child, which would be undoubtedly a crime in Michigan and a very serious one, you couldn't even investigate a baby that dies at home in those circumstances to see why that happened. In addition, if you had a grossly negligent doctor in another state who maimed or even resulted in the death of a patient, and then that person fled to Michigan to avoid prosecution, we wouldn't even be able to extradite them to the other state, because to do so would be taking an adverse action against an individual based on their based on a perceived pregnancy outcome. Again, the scope is absolutely enormous, and that is doubled down then in the next provision. Nor shall the state. I'm sorry, because that was all for the mother. The next one is what would apply to that out-of-state doctor. The state cannot penalize, prosecute, or take adverse action against someone for aiding or assisting a pregnant individual in exercising their right to reproductive freedom with their voluntary consent. So as long as they had the consent of that person in the other state, it was a Dr. Gosnell patient and they signed a consent form, not an informed consent form, but simply voluntary consent. We'll come back to that. We could not extradite them. In addition, for someone here in Michigan, someone aiding or assisting a pregnant individual in exercising the right, that someone is not defined. In other words, a doctor could be performing this, a nurse could be performing this, a PA could be performing this, or a non-medical professional could be performing the abortion, and the state would have no ability to take any actions against that person. It's a complete deregulation of the abortion process, opening it up to anyone. And so long as they had voluntary consent, again, this is that notion of bringing in the desk clerk or the secretary or the accountant. The abortionist in Michigan could include anyone else that they wanted to assist in that abortion procedure. And so long as the mother said yes, they would have no recourse. So what this means in practice is that even women who are injured by abortionists may have trouble going into a court to enforce their rights. So assume that you've got like a Dr. Gosnell type abortionist here in Michigan who maims or causes the death of a mother, a female patient. Well, this says that you can't penalize, prosecute, or take adverse action against someone. Well, if they would try to sue in the court system for that medical malpractice, for that gross negligence, that would be a court, which represents the state, taking an adverse action against someone aiding or assisting a pregnant individual in exercising the right to reproductive freedom. So there's a good argument that there would be no more rights for moms to be able to sue abortionists who commit medical malpractice. Now, I know some of you out there are doctors, or you have doctors in your family, you've got doctors who are friends. Ask them if there's any other area of medical practice where you can have a non-medical professional perform a procedure and where that person, as well as the entire medical profession, is absolved of any liability for any malpractice, so long as you have given voluntary consent ahead of time. And then also ask them what they think about this voluntary consent notion, because medical malpractice requires informed consent. You have to inform someone of all the options, all the downside risks. And this eliminates informed consent for abortion procedures. So long as you have someone voluntarily consenting, that's it. All right, we're getting close to the end here. There's another definition here on fetal viability. You'll recall earlier, it sort of kind of gave the ability of the state to protect life after fetal viability, although many of those things, as we recognized, were immediately taken away by the definition of state compelling interest. But it defines fetal viability to mean the point in pregnancy when a baby can be sustained, of course it doesn't say baby, it says fetus, outside the uterus without the application of extraordinary medical measures. extraordinary medical measures. Now, if a baby is born at 23 weeks gestation, it's a viable baby. It could survive outside the womb, certainly. However, it could not survive without extraordinary medical measures. Certainly that baby would be in a NICU, there would be oxygen, and there would be other things to help that baby. And so now they're pushing the fetal viability line far past 21 or 22 weeks to the point where a baby can survive completely on its own without the application of any extraordinary medical measures. So even with respect to the fetal viability line, they've pushed it far past where it is under the Roe regime. So this ballot initiative is incredible. And again, it's important that we be educating those around us, whether it be family, friends, neighbors, co-workers, people on the street, about this. However you feel about abortion, there are serious problems with how this ballot initiative is written. It protects grossly negligent abortionists. It allows unfettered abortion until birth. Minors can obtain abortions and possibly gender sterilizations without their parental consent. And there are effectively no safety regulations so long as someone gives voluntary consent or the abortion clinics don't think that they're necessary. With respect to every single one of those, there's no other area of medicine where we would allow that to happen. Now you may be thinking, well, how can I change someone's mind about this? Well, if you know someone who's thinking about signing the petition, make sure that they know. In addition, in always polite, respectful, loving ways, it's possible to speak into the signature gathering debate. I just got an email from a friend. He had gone to a movie at Celebration Cinema here in Grand Rapids, and there was someone outside on the sidewalk who was collecting petitions. And he went into the manager of the movie theater and said, do you know that there's someone out there who's trying to put a right to abortion in the Michigan Constitution and gathering signatures for that on your private property? And the manager did not know that, and they removed the person from the premises. No more signature gathering. There was another individual, and she was going up to a store, and there was a petition gatherer there with a table, and they asked her if she'd be willing to sign the petition. And so she entered into a respectful dialogue with them. And she started to explain some of the things that were in this terrible constitutional amendment. And that signature gatherer, who was being paid $26 an hour, ripped up the petition signatures, including the signatures that they had already gathered, and quit on the spot. That's the kind of impact that you can have when you speak the truth into this terrible evil. Now, I've covered a lot in a very short period of time on the ballot initiative, and some of it is pretty legal too. To the extent that you're looking for resources, please go to the Right to Life of Michigan website, because they have flyers, bullet point statements, other information, even stuff that you can hand to other people that will explain some of these things, including all the Michigan laws. I think at last count, they've counted 47 Michigan laws which could be invalidated by this constitutional provision. And you can use that for that kind of advocacy. But caution, we don't want to be abusive. We don't want to be confrontational. We should never be yelling, screaming, stealing petitions from someone. You can even get arrested for interfering with a petition gathering process. But we all have a First Amendment right, particularly on public sidewalks and in parking lots and at festivals and things like that, to engage people in peaceful dialogue. And I think we may discover that there are many more of these petition gatherers who do not know what they are gathering signatures for. Okay, I think I have covered now my first three topics, and so now we're going to talk a little bit more about what we can do about all this. I've given you some tips, but there's obviously a lot more. First of all, we all need to be well educated about how to speak about pro-life issues. We've given some talking points about the language. Someone just in the chat put the link in there where you can go and you can get more information about that. But we need to think about how we talk about this issue. First, when we talk about abortion, we should never talk about an abortion ban in Michigan being lifted or repealed by a US Supreme Court case. We should talk about protecting babies, about protecting unborn life, about protecting innocent life, about protecting mothers from the horrors of abortion and potential medical complications, and protecting society from the coarsening that happens when you have a society that willingly takes innocent human life. And one of the reasons that We have so many evils in our country right now, from the way that the elderly are abandoned, to the way people are attacked and shot on the street, to the way that kids are neglected and abused, comes from a cultural mindset that allows itself to be corrupted by the taking of innocent human life. That's important. When we're talking about the US Supreme Court decision, it's not about overturning Roe versus Wade, although I may have said that a couple of times tonight. It's not about taking away a constitutional right. It's about restoring the meaning of the US Constitution. It's about restoring the right of people everywhere to be able to go to their state legislators or their neighbors in a ballot initiative process and be able to have face-to-face conversations about these important issues. There are many wonderful resources out there online. Right to Life of Michigan has them, but so do many other pro-life groups, to help you talk about the issue of abortion itself. Just a quick overview tip on that. Always try to start the conversation with a 2-year-old child, because 99.99% of people think that there should be no right to be able to take your child's life once they've reached 2 years of age. Now, there are some philosophers and others on the fringe pro-choice movement who would say, even there, if the child hasn't reached the age of reason, you should be able to take their life. But you're not going to run into those people in everyday life, hopefully not in your family or in your workplace. So everyone will agree that you can't take a 2-year-old child's life, because that would be wrong, no matter what you think about anything else. Well, what's the difference between that 2-year-old and the baby that's in utero when the mother has reached her due date or is even a couple of days past it? That baby is smaller than the 2-year-old, but we don't allow people to take human life based on their size, or otherwise you could take the 2-year-old. The baby can't survive all on its own, but neither can the 2-year-old. If that was the qualification, then not only toddlers, but also the elderly, you could take their lives against their will, because they don't have the ability to take care of themselves and survive on their own. Maybe you would say that the baby's brain is not as well developed as the 2-year-old's. Well, why should that matter? We don't draw differentiations in whose lives can be taken based simply on the intellectual maturity of an individual. Again, otherwise that would allow you to take the child, or to take someone who's mentally impaired, or to take the life of an elderly person who has Alzheimer's or dementia. And none of those are reasons that would justify taking the life of those individuals, and so it shouldn't justify taking the life of the baby either. These are just some of the ways that you can be talking about that debate. Even with respect to the Dobbs case itself, it's about a 15-weeks law. Around the world, the overwhelming majority of countries will not allow an abortion after 15 weeks. Well, why is that? Because at 15 weeks, a baby is fully formed. It has eyelids that blink. It can suck its thumb. It can taste the food that its mother is eating. It responds to outside stimuli. And it's possible, based on the most latest, greatest medical research, even be able to experience pain. And that's something we could get into in the question and answer if you have more questions about that. No one should think that the taking of that innocent human life is right under any circumstance. Now, another side of this discussion, well, what about the moms who simply can't afford to keep their babies? They may be young women in high school or college, and they don't have the economic means to help with that. What do you say to them? And that's an argument that we've heard from Governor Whitmer, as she's justified why she's moving forward with this litigation. Well, that's why we have the Catholic Church and pregnancy help centers and all kinds of wonderful resources to come around those women, to give them the resources that they need. And it's very hypocritical of the governor of the state of Michigan to be using economic disadvantage for a reason to allow mothers to take the lives of their unborn infants, because the legislature appropriated $16 million to help those women through pregnancy centers in last year's budget cycle, and the governor line item vetoed it. That tells you a lot about what her priorities are, that she doesn't want to give women real choices, because a real choice would be able to provide those resources and then let her decide for herself. So those are some of the talking points. Again, there's many more resources out there. There's some excellent books that you can find on these subjects, and I encourage you to read them. And then I encourage you to start getting active. So one way certainly is going to be to get involved in pregnancy help centers and the churches and things like that, where we can walk alongside these women. We've been doing this for decades, but we need to redouble our efforts, because if we are able to protect innocent human life beginning at conception in Michigan, there are going to be more mothers who are in these difficult situations, and they need our help. And so you need to be looking for opportunities to volunteer, to donate your time, your talent, your treasure to these organizations, to set up whole care systems at your local parish so that if you got a young mother or a family, that there are ways that the parish can support them. We need to walk alongside these women. In some states, already they're allocating tens of millions of dollars, like in Texas, anticipating the Dobbs ruling so that they'll be able to help women and families in this way. In addition, we need to engage more people in these conversations. If you haven't ever had a conversation with your kids about these issues and they're even 10 years old and up, then we need to be talking about them. When your kids go off to college, we want them to be pro-life advocates. Get them invited or involved in Students for Life, get them going to the March for Life. Mark and I have done that as chaperones in the past. There are all kinds of opportunities to make sure that we're raising that pro-life generation. But this includes more than that. It includes family members, it includes friends, it includes neighbors, others that might go sign one of those petitions or vote in this fall's election. These are important issues, and we've been quiet about it for far too long. And the election is a big deal. Given the millions of dollars that Planned Parenthood and others are going to be spending on the signature gathering process, even despite our best efforts to engage, it's entirely possible they're going to get those signatures. And then we're going to have one heck of a fight on this fall's election ballot. And then we're really going to have to let everybody know exactly why this constitutional amendment would be so destructive to life and children in Michigan. In addition, Right to Life of Michigan endorses pro-life candidates. It's more important than ever that we have members of the legislature, members of the executive branch who will uphold and defend human life. This issue has never been more important. The Catholic Church talks about how we should think about elections. And I know sometimes that's a difficult issue because you can find things to like and dislike about candidates on either side of the political spectrum in the way that they think about Catholic Church's teaching. But the USCCB has said in the past and has reiterated in the last election cycle that the right to life is the foremost political issue that we consider when we go to the ballot box, because nothing is more fundamental. If we don't have life, then there's nothing else to talk about. What's more, when you're talking about an abortion, you're talking about taking the most innocent life imaginable, that of an unborn child. And so we need to be active in that. So all these things, educating yourself, dialoguing with others, getting involved in helping young mothers when they need it, being involved in the electoral process. And then finally, something I've touched on a number of times here, prayer. There are so many opportunities for prayer, whether it's individual prayer, whether it's novenas, whether it's organizing prayer initiatives at your churches. We need to be praying for the US Supreme Court justices. We need to be praying for the Michigan Supreme Court justices. We need to be praying for everyone in the pro-life movement. We need to be praying for unborn babies and their mothers and their families. And perhaps most of all, and this is the most difficult, is to pray for those who disagree with us on all these issues. Pray that they will have a change of heart, because their souls are at risk too with the policies that they support. And so there's nothing more important that we can do than to love them and to pray for them, pray for their conversion. After all, we only love God and Jesus Christ as much as we love the person that we most dislike here on this earth. It's easy to love those who love us. It's easy to love those who agree with us. It's very difficult to love those who have a very different view of the world than we do. But we can love them by praying for them. So with that, I have come to the conclusion of my 4-part walk through Dobbs in a post-Dobbs world. I hope that you've got lots of questions. As a lawyer who argues in the US Supreme Court, I'm more used to answering lots and lots of questions than I am presenting for long periods of time. So please speak up. And I think Mark indicated if you could use the raise your hand function, that would be most beneficial to coordinating this conversation.
Yep, thanks, John. Yeah, a reminder for those on Zoom to please use the raise hand function, and that'll move you up to the queue, top of the queue, and we'll be able to moderate the discussion that way. We do have a question here. Let me move the camera in place.
Thank you, John, for all that you've shared with us tonight. It's been very informative. One thing that you really haven't mentioned is the fact that increasing numbers of women are no longer going to an abortion center to receive an abortion. Instead, they're getting in the mail their 2 pills and having the abortion at home. And given that wrinkle, how are we going to deal with that? And what safeguards would be in place either in a post-Roe world, or if by some chance our Michigan Constitution were, you know, our statute is able to be upheld, given the fact that so many of these medicines are coming from out of state. So if you could address that, I'd be grateful.
Thank you for raising that, Sue, because an increasing percentage of abortions are taking place through these terrible medical poisons. And it's actually gotten worse in the last couple of years because once COVID happened and it was more difficult for some people to go see a doctor, which would ordinarily be an absolute prerequisite to getting one of these poison pills, the Biden administration lifted the requirement that you see a doctor. And so some women are getting these pills through the mail without ever having seen a doctor, without even being screened. And that's troubling because they don't learn the medical and the mental health implications of aborting their child through taking one of these poison pills. But in addition, it doesn't allow a doctor to screen and make sure that that young woman isn't being coerced into doing this. In fact, it could even be someone who is in the middle of a minor trafficking ring, where a pimp is forcing them to take these pills in order to eliminate the baby that's in their womb as a result of the trafficking that they've been engaged in. So it's extremely dangerous. So at the federal level, it's going to be very difficult to do anything in the short term because this administration is as supportive of that line of taking young life as any in the history of our country. But as you think about what we're doing here in Michigan, at least arguably that 1931 law, it hasn't been interpreted because it hasn't been brought into court, but at least arguably would apply to that situation. Because after all, that 1931 law prohibits the taking of innocent human life, the person performing the abortion. And in the case of mailing someone one of these poisonous pills, that the person who sent that pill, who allowed the prescription, would fit the description of the statute. It would not be a prosecutable offense for the mother who took it, but it could be for the doctor who sent it. Now, what about this issue of out-of-state commerce? Well, that gets a little bit trickier because the state of Michigan does not have the ability to regulate outside its borders. We can prohibit the importation of illegal drugs, but we could not go outside of the state to enforce those kinds of things. So what that would mean effectively is that there could be a crime established in Michigan when someone, say in another state, sends the pill to someone, but unless that person voluntarily crossed our border, we wouldn't have much that we could do about it. Now that said, in a post-Roe, post-Dobbs world, there are going to be many other pro-life states out there that would be willing to work with a pro-life Michigan in coordinating that kind of enforcement. And you can have reciprocity agreements so that if someone commits a crime, say in Texas or Mississippi or Ohio, and that crime is completed by the delivery of the poison pill to a mother in Michigan, where once that information was revealed, the other state would be able to prosecute. Eventually, what we would love to see is a pro-life Congress and a pro-life president enact something more long-lasting into federal law. If you had a federal statute that criminalized the provision of these types of poison pills, then U.S. attorneys across the country would have the ability to do that. And you wouldn't have to rely on sympathetic states to be able to enforce laws like that. So like with many of these things, it's something where there are certain things that we can do in the short term, but it's going to take an enormous amount of pro-life elective work in order to be able to have long-lasting, permanent national solutions in the long run.
Thank you.
I might as well jump in. John, yeah, I just wonder about some of the fundamental points you made early on. I mean, everybody talks about this as a constitutional right. You said there is no, there's nothing in the Constitution about this. So then why do we say that Roe v. Wade established a constitutional right? It wasn't in the Constitution. How is that not a non sequitur?
It is, and that's the way the media likes to talk about it, and the way they like to talk about me and others who are involved in this work as anti-abortion activists as opposed to pro-life advocates. The proper way to describe that would be that the US Supreme Court made up a constitutional right that didn't exist. But it is a non sequitur. It would be like saying that I have a constitutional right to have the government provide me with a cat or a dog once I turn 21 years old and move out of my parents' home. You're not going to find that in the Constitution either. And that right is about as deeply rooted in the Constitution as the right that the Supreme Court made up in Roe.
So it's never actually accurate to say, well, this established a constitutional right.
Correct.
It wasn't, and it can't be. Okay.
It's not possible. That's a false statement.
And just for the sake of tying the bow, we have China, North Korea, United States, and you said 4.
The other is Canada.
And Canada. Okay. I do wonder if Roe is thrown out, is Doe thrown out too?
Yes, it would be.
Okay.
They're inextricably joined at the hip.
Okay. And then the same question, so establishing a state constitutional right would have to be a matter of changing the Constitution. There is no state constitutional right for anything that has to do with abortion.
That is correct. You'd have to have this amendment go into effect, and then it would be written into the Michigan Constitution. But it's possible that the Michigan Supreme Court justices will make up a constitutional right in Michigan's Constitution in the same way that the US Supreme Court justices did in 1973. That would be disingenuous. It would be unlawful. The Michigan Constitution and the 1931 pro-life law have existed peacefully together since 1963, 59 years. So there's no reason to believe that that's the case. But if 4 justices write that into an opinion, that will at least temporarily become the law in Michigan as well.
Thanks.
On that note, there was, before we go to Karen, I see her hand up. There was a question in the chat about what is the name of this ballot and the amendment, the suggested amendment change. Could you address that?
I don't have the exact title in front of me. It's very innocuous. It's something like, the Reproductive Freedom for All Act or something like that. What Right to Life of Michigan has called it, and I would encourage you to use this instead, is that it's the Anything Goes Abortion Amendment. The Anything Goes Abortion Amendment. And then you can tick off a couple of the things that we discussed earlier. It allows abortion on demand all the way through the end of pregnancy. It allows non-doctors to perform abortion procedures. It allows minors to get abortions and gender sterilizations without the consent or even knowledge of their parents. It removes any ability for women to be able to sue their doctor if they commit malpractice or gross negligence. It is the Anything Goes Abortion Amendment.
Thanks, John. Karen, you have your hand raised. Go ahead and unmute yourself.
Thank you, John, and thanks, Mark, for doing this. I find that when I talk to people about this, people that are not that well informed or are not sure where they stand on the issue, that they gloss over when you try to give them the facts, and they say, well, the majority of people in the country want abortion in some form. And even when I try to say, well, that's not really true, and all the stats about younger people, that's what the media keeps feeding them. And so, I think the recent comment I heard was 73% wants abortion legal. And so it's almost like, how do we get people to understand that in some ways, this is our Abraham Lincoln moment? Something grossly unjust was happening, like slavery. And then abortion's even worse than what we went through as a country. And we have to just end it and get on with it and start healing from all of the ramifications. But how do we really get people to engage that have decided they don't want to talk anymore? They just think they're on the right side.
Yeah, well, just for everybody's information, and this isn't necessarily going to persuade someone who's already kind of in that camp, but those numbers about people who support are wildly misleading. That 73% number comes from a poll where they asked people if they wanted the Supreme Court to overturn Roe versus Wade. Well, the vast majority of people don't know really what Roe versus Wade is about. They don't know that it's a decision that completely makes up a right in the Constitution that isn't actually there. They don't realize that it creates abortion on demand effectively all the way through pregnancy if you can just claim a physical or a mental health issue. And that when you really get down to brass tacks and you talk to them about what it means, you know, if you could ever have that decision, the number drops below 50%. But I doubt if they've heard 73% in the media that you're going to be able to move them off that mark. So what my focus would be right now is this anything goes abortion amendment. You know, it may be that a majority, even a supermajority of people in Michigan support a right to abortion, but you need to know what the words are in this anything goes abortion amendment, because it's not simply about a right to abortion. It's about giving the minor the right to be able to do this. It's about the gender sterilizations. It's about the medical malpractice actions being removed. It's about non-medical professionals being able to perform abortions. It's about all these other things. To the extent that you've got someone whose kind of mind is made up, those are the kinds of things that might maybe bring them back from the brink a little bit. And if they go investigate and they read it and they see that all those words are actually in there, just like you said they were, then maybe they'll come back to you for another conversation and you can start talking about the 2-year-old. And then you can talk about the baby at 9 months, and then you can talk about life more generally. So I think, although this anything goes abortion amendment is horrific and awful, it does create an opening to have conversation and dialogue, because it is so far reaching and so extreme and outrageous that even those who might disagree with us fundamentally should be able to see that this is wrong and should never be enacted.
So do you think, in answer to that then, that the people that want an incremental approach to, I mean, yes, we would take a 15-week ban over nothing, but if it turns out to, when you're advocating, people are saying, well, I don't really want it to all be gone. So, you know, they confuse the issues. Do you think that that's really something we need to push back on?
Not right now, because we have that 1931 law in place. If we were trying to pass a law or a constitutional amendment that drew the line, say, at 6 weeks, you know, then you would have to be engaged in that kind of debate. But right now, we just need to persuade them that this amendment is too extreme and outrageous for anyone to support, even someone who thinks that abortion generally is a good idea. And then we'll have the backstop, hopefully, of the pro-life law that's on the books.
Okay. Last question. I just wondered, I thought I heard that we had a law on the books from the 1800s.
Yeah, that's a prior version of the 1931 law. So I believe it was 1846 was when our first pro-life law was enacted. But then the 1931 law cleaned up some of the language and replaced it.
Okay.
So we've been a pro-life state since the mid-1800s, but the law that will spring to life is the one from 1931.
Okay, thank you.
Yeah, but there are a lot of people who are confused about that because they've heard both of those dates.
Other questions, comments? I certainly want to give a shout out to Rebecca Masti from the Michigan Catholic Conference and her fellow staff people that are on this call this evening, and for all of their work at the Michigan Catholic Conference in being able to do the legislative advocacy that is so necessary for the common good and based on our Catholic values and our Catholic faith.
And I want to give a shout out to the bishops of Michigan too. You know, there are some who say they wish that the bishops were doing more, but when the litigation was filed by the governor and the Planned Parenthood, the Michigan Catholic Conference, which is the organization of our Michigan bishops, immediately jumped into action. I was talking to them just days after that litigation was filed. They have been so strong on this issue. And so we should be very encouraged by the fact that we have such compassionate, wise, and proactive shepherds here in the state of Michigan, including Bishop Okoviak right here in the Grand Rapids Diocese. And we should continue to pray for them as well, because they're going to hear from people who aren't happy about the Catholic Church in Michigan standing up for unborn life. But we're so glad that they are.
Any other questions or comments or conversation with John?
Well, I'll say one more thing. What do we do when the time comes to show that we are standing up for the women and babies? Like, you know, we can say find your health pregnancy, and I found out today that Grand Rapids Right to Life has a big online presence with links, and banner ads and all that on social media, but you know, if we have protesters out on our streets or in our churches, it seems like we need to have a pro-life presence too, with signs with 1-800-HELP numbers or whatever we can to say that we do have resources and people ready to support you.
I agree completely. You know, we need to always show the beauty and the truth on our side, and not devolve into kind of the ugliness that you see in the pro-choice movement. But we do need to increase media presence and door-to-door things and all that sorts of stuff. And that's why I encourage everyone to go to that Right to Life of Michigan website, where you're going to be able to print some of those resources that you can carry with you to talk to people, you know, whether it's a crisis pregnancy or whether it's about this anything goes abortion amendment. There are lots of materials that we can take with us so that we're armed to do that. You know, and as soon as you hear about a young single mother who might need some help, man, we need to grab her and hold her in the church's arms tightly and provide you know, economic, emotional, spiritual support as much as we can to help them be able to not only choose life, but to thrive in making that choice.
Are we allowed to hold things at our churches?
I was speaking metaphorically about wrapping someone up in the church's arms.
Well, I know, but I mean, are we allowed to have you
mean
come in and
events,
speak at our
Karen?
churches or events at our churches?
Absolutely. Just to be clear, for any of you who happen to be, you know, parishioners or employees of Catholic churches, and you're wondering where the lines are about your nonprofit status, federal law prohibits a church from engaging in political advocacy, but that political advocacy concerns candidates. So the Catholic Church cannot endorse a candidate. They couldn't hold a fundraiser for a candidate on site, but churches absolutely can and should be engaged in issue advocacy. So parishes can host evenings like this one where you talk about the Anything Goes abortion amendment. In fact, if you want to take this video, it's going to be on the Catholic Information Center's YouTube channel. Schedule a night at your parish where you can get 100 people together and have everybody watch it. You can assist pregnant mothers out of a church. You can engage in political advocacy with respect to the amendment and legislation on site, provided that it's limited to the issue and not to a candidate. That's why last year when we had a pro-life ballot initiative, all the Catholic churches in Grand Rapids were able to have signature pages inside the vestibules of the church so that we could sign those, or the narthex. So there's no prohibition whatsoever on churches being places for pro-life advocacy, as long as it doesn't devolve into supporting or opposing candidates.
Yeah. With regard to legislative advocacy, John, and we have time for just one more question in the chat, is the question, is it helpful to write the governor or the Michigan Supreme Court justices? What legal ways can we let our elected officials know how we feel?
Certainly write your state senator and your state representative. Whether you want to write your governor or the attorney general, that's up to you, as long as you do it respectfully. I think it's unlikely they're going to change their mind, but there's no harm in communicating with them and letting them know that you're praying for them. Rather famously, in California, there was the home diocese of Nancy Pelosi, and before the most recent decision where she was told that she could no longer present herself for communion in her home diocese, they were sending roses to her on behalf of individuals who wanted to pray a novena for her and her conversion. I think that can be an effective way to reach someone's heart. Now, with respect to the Michigan Supreme Court justices, it would not be appropriate to write them letters or to try to lobby them in the same way it would not be appropriate to write the US Supreme Court. However, at some point, likely in the next couple of months, there is going to be a Michigan Supreme Court oral argument at the Hall of Justice in Lansing. And when you hear about that, I encourage you to go to that. And not only do I encourage you to go, I encourage you to bring babies and children and make it the biggest, most loving pro-family event that the Michigan Supreme Court has ever seen. I've been in Lansing and in Washington, DC during contentious US Supreme Court and Michigan Supreme Court matters, and there will often be groups gathered on both sides. We need to let not only the justices, but the entire state of Michigan know that there are people out there who are standing up to protect innocent life, and that there are severe consequences to the Michigan Supreme Court making up rights that allow those lives to be taken. So there will be an opportunity to engage in some very vocal, loving advocacy when that moment arrives. And just one last note, because I've mentioned this several times about being beautiful and respectful and compassionate. Number one, it's important that we act in those ways because that's the way Christ calls us, not to be demeaning or hateful towards anyone. So it's the protection of our own souls as much as it is the protection of souls on the opposite side of these issues. But in addition, there's persuasiveness to beauty. The year that Mark and I were in Washington, D.C. with a bunch of the high school pro-lifers on the March for Life from the Grand Rapids Diocese, our group from our parish stayed over for an extra day so that we could do some Washington, D.C. sightseeing. I guess they all did. But in order to get to where we were going, my group had to walk through the Women's March, which was taking place the very next day. And there were unbelievably crass and vulgar signs and speech and the way that people were dressed. And we had to talk about that later, because during the March for Life, you saw nothing but love and compassionate and care and beautiful babies. And ask those kids, well, you saw what happened yesterday, you saw what happened today. Where do you think that the truth lies? And to a person, every single one of them was able to say, well, it's in the beauty. So it's the beauty of the pro-life movement, the beauty of the church's teachings on life that will ultimately carry the day, change minds, and save souls. And so we just need to have that constantly in mind as we're engaged in these conversations.
John, thank you very much for your presentation this evening and for helping us kind of navigate, as I'm glad Karen brought up about there's the media coverage and some of the media sound bites and the things we hear in the media. And then there's all the legalese, right? All the language of these various ballots, the litigation, and even the court case for the Supreme Court, and helping us just navigate that as Catholics, giving us the language and the tools that we need to call to action. So thank you very much.
Thank you, everyone. God bless.
And we want to thank all of you for attending this evening. We're so glad that this kind of technology can help bring people together so we can help build community, foster faith, and certainly advocate for the least and the lowly in our society. And we hope that everyone can join us for future events on June 9th, where we'll be hosting Sister May K. Oostdijk. We'll be doing a presentation on the Eucharist in our life, the mystery to be believed. The U.S. bishops are kicking off a national Eucharistic revival in dioceses around the country on June 19th on Corpus Christi Sunday. And to help us get ready for that, we'll be hosting Sister Mary K. Oostdijk for 2 presentations, one in the morning and then again in the evening at this time slot at 7 o'clock. So we hope you can join us. All our details are on the Catholic Information Center website. And as John has repeatedly asked us and called us to action to pray, let's do that now as we close our evening together. In the name of the Father, the Son, and the Holy Spirit. Amen. Lord our God, we thank you for the gift of revealing yourself to us. As Trinity, you share in the communion of love and life, and you invite us to share in your divine life. We thank you for the gift of life. We ask that you send your Spirit to guide those who govern us and who make decisions, our elected officials, as well as the residents in this country, to give us insight and wisdom. Guide us by your strength and power. We ask this in the name of our Lord Jesus Christ, who lives and reigns with you in the unity of the Holy Spirit, one God, forever and ever. Amen.
Amen.
And may the God of hope fill all of us with joy and peace through our faith in him. Thank you.
Thanks, Mark.